Nah. She didn't even look up from her phone when I walked into the courtroom. That was the part that stayed with me. Not the 3 lawyers she had sitting at her table. Not the court reporter already typing before the session opened. Not the bailiff who glanced at me once and then looked away like I wasn't worth a second assessment. It was the fact that my wife, the woman I had spent 7 years building a life with, couldn't be bothered to acknowledge that I had entered the room. I set my folder on the table. One folder, pale blue, 2 inches thick, with a rubber band around it because the clasp had broken 2 weeks earlier and I hadn't had time to replace it. I pulled out the chair, sat down, and placed both hands flat on the table in front of me. The lawyer closest to her, the one she'd introduced to her mother as the best family attorney in the state, finally looked over. He didn't say anything. He just looked at my folder, then at me, then leaned sideways and said something quiet into my wife's ear. She smiled. I had seen that smile before. It was the same one she used when her younger brother said something she considered beneath her. Patient. Tolerant. Faintly amused. I looked straight ahead. The judge hadn't entered yet. There was still time, and I had spent 11 months making sure that when the time came, I was ready for every second of it. My wife's name is irrelevant to this story. What matters is who she was to me and who she became. When we met, I was 26 and finishing a master's degree in structural engineering. She was 28, already 3 years into a career at her family's logistics company. We were introduced at a birthday party for a mutual friend, and within 2 hours we had moved away from the group and were standing on the back porch arguing about whether risk aversion in financial modeling was intellectually cowardly. She said yes. I said it depended on who was bearing the risk. She laughed and said I was the first man she'd talked to in months who wasn't trying to impress her. I wasn't. I was just interested in the argument. We got married 4 years later. Our daughter was born 11 months after that. Our son followed 18 months after her. The decision for me to stay home wasn't dramatic. Her company was growing fast. Her father had started it, her uncle ran the operational side, and my wife was being positioned to take over within 5 years. The salary difference between her income and what I would have made as a junior engineer at a mid-sized firm was not close. The math was simple. I stayed home. And I loved it. That part matters too, because it gets erased in the version of events she told the court. I wasn't a man who settled. I wasn't a man who gave up something to accommodate his wife's ambitions. I was a man who chose his children, who woke up at 6 every morning and made breakfast and drove to school and sat through every pediatric appointment and coached the Tuesday soccer practice and read every bedtime story twice, because my daughter always asked for it twice and I never said no. I was their father. Fully. Without reservation. For 5 years. The marriage ended the way some marriages end, not with a single rupture but with a slow, widening distance that neither person names until it's too late to close. By the time she told me she wanted a divorce, I was not surprised. I was devastated. But I was not surprised. What surprised me was everything that came after. The first filing arrived 8 weeks after we separated. Her attorney requested primary physical custody of both children, citing, among other things, my lack of professional employment, my financial dependence on the marital household, and what was described as documented concerns regarding the respondent's ability to provide stability. I read that paragraph 4 times. Documented concerns. I had no idea what that meant. I had never been investigated, evaluated, or reported. I had never been the subject of anything involving my children's welfare. I was the person who had been their primary caregiver since birth. I called 3 family law attorneys that week. The consultations all went the same way. They listened, they nodded, they gave me their hourly rate. The lowest was $380. The retainer to begin representation was $7,000. I had $1,100 in my personal account. Everything else was in joint accounts that had already been frozen as part of the filing. On the 4th call, the attorney, a woman who had been doing family law for 20 years, said something I've thought about many times since. She said, going pro se in a custody case is not impossible, but you need to understand that the other side has institutional knowledge of this courtroom, this judge, and these procedures. The only way to offset that is preparation that most people are not willing to do. I told her I was willing. She said, most people say that. I said, I have 5 years of detailed records of every doctor's appointment, every school event, every emergency, every decision made for my children. I have a spreadsheet going back to when my daughter was 3 months old. I have photographs, pediatric visit summaries, teacher correspondence, immunization records, the names of every coach, tutor, and babysitter we've ever used and the dates they were used. I have text message records and email records and home calendar exports. I have 5 years. There was a pause on the line. She said, "Then you might be okay. File your response carefully. Don't get emotional in that courtroom. And get familiar with your local rules of evidence before the hearing date." I thanked her and hung up. Then I sat at the kitchen table for a long time, listening to my daughter practice piano in the other room, badly, cheerfully, the same 4 bars of a song she'd been learning for 3 weeks, and I made a decision. I was going to walk into that courtroom, and I was going to win. The hearing was set for 11 months out. I used every one of them. I read the state family code. I read the procedural rules for domestic cases in our county. I read every public ruling by our assigned judge that I could find. He had been on the bench for 14 years and had a reputation for being methodical, impatient with theatrics, and deeply protective of children's continuity of care. That last part I memorized. I organized my records into a binder system. 12 binders total, color-coded by category: medical, educational, daily care, communications, financial. Each entry dated, sourced, and cross-referenced. My neighbor, a retired paralegal, looked over my organizational system one afternoon and said quietly, "Whoever is going up against you does not know what's about to happen." I didn't feel confident. I felt terrified, but I kept working. 6 weeks before the hearing, I received the disclosure from my wife's legal team. It included a psychological evaluation of both parents, conducted by a licensed evaluator they had retained. The report on me was 8 pages long. It described me as passive, conflict avoidant, and raised questions about whether my decision to leave the workforce reflected diminished initiative that might translate to inconsistent structure in a primary parenting environment. I read it twice. Then I pulled up the evaluator's published academic work. She had written extensively in peer-reviewed journals on the psychology of primary caregiving parents and the cognitive demands of home-based childcare. In one paper from 3 years earlier, she had argued explicitly that stay-at-home fathers demonstrated above-average organizational capacity and emotional attunement due to the sustained demand of caregiving without institutional support structures. Her published conclusions directly contradicted the characterization in her own paid evaluation. I printed that paper and put it in a separate folder, a red one. The morning of the hearing, I woke at 4:30. I showered, made coffee, reviewed my notes for 2 hours. My daughter had stayed with my mother the night before. I had called her before bed and she'd asked me if I was nervous, and I'd said a little bit, yeah, and she'd said, "You're the best dad, Daddy. The judge will know." I didn't trust myself to respond to that. I just said I loved her and I'd see her tomorrow. I drove to the courthouse, parked, sat in the car for 4 minutes, then I got my folder and went inside. My wife's lead attorney opened by painting a picture. It was well done, I'll give him that. He described a marriage in which my wife had carried the financial and professional weight while I had enjoyed the domestic role. He used the word enjoyed deliberately more than once, as though the years I had spent caring for our children were a kind of extended leisure. He described my current situation as one of structural dependence and argued that awarding primary custody to a parent without income or professional standing would expose the children to instability. He did not mention the spreadsheets. He didn't know about them yet. When it was my turn to make an opening statement, I stood up. I heard my wife say something quietly to the attorney beside her. I didn't catch the words, but I caught the tone. I began. "Your Honor, I'm going to keep this simple. I have been my children's primary caregiver since the day my daughter was born. I have documented that care in detail, consistently, for 5 years. I am going to show this court exactly what that care looked like, not in general terms, not as a characterization, but specifically, day by day, decision by decision, and I'm going to ask this court to make its custody determination based on what the actual record shows, not on what it might assume about a parent who chose to stay home." The judge looked at me over his glasses for a moment. Then he wrote something down and said, "Proceed." I called the pediatrician first. She had agreed to appear voluntarily. I had called her office 8 months earlier, explained the situation, and asked whether she would be willing to testify about the nature of my involvement in my children's medical care. She had said, without hesitation, yes. Under my questions, she confirmed that in 5 years of treating both children, she had seen me at every scheduled well visit, every sick visit, every follow-up. She confirmed that I was the parent who calls, who asked questions, who kept the vaccination records current and brought them to every appointment. She confirmed that when my son had a febrile seizure at age 2, I was the parent in the emergency room, and that I had arrived with his complete medical history written on a single sheet of paper that I handed to the attending physician within 90 seconds of arrival. My wife's attorney cross-examined her. He asked whether my wife had also attended appointments. The pediatrician said yes, occasionally. He asked whether that demonstrated involved parenting. She said it demonstrated presence. He didn't follow up on that. Then came the evaluator. My wife's attorney walked her through her report point by point. She described her methodology. She described her observations. She characterized me, again, as passive and potentially understructured. When he finished, I stood up. I placed the red folder on the table and opened it. I said, "Dr. Stode, Ellison, you published a paper in the Journal of Family Psychology in 2021. I have a copy here which I've already submitted as Exhibit 14. The paper is titled Cognitive Load and Emotional Regulation in Non-Institutional Primary Caregivers. Are you familiar with it?" She said she was. "In that paper, you argue that stay-at-home fathers demonstrate, and I'm paraphrasing your language here, above average organizational and attunement capacities relative to employed parents, due to the absence of institutional structure requiring them to develop those capacities independently. Is that an accurate summary of your published conclusion?" A pause. "Generally, yes. Your evaluation of me describes my personality profile as passive and potentially understructured. Is that characterization consistent with the conclusions in your published research?" The room was quiet. She began to answer and then stopped. She said the evaluation addressed specific context, not general typology. I said, "Your Honor, I'd ask that the court consider the discrepancy between this evaluator's published academic conclusions and the characterization she produced in a paid evaluation in this case." The judge looked at the paper. He looked at the evaluator. He said, "I've read Exhibit 14. We'll be returning to this." My wife's lead attorney leaned forward. For the first time since the hearing started, he looked less certain than he had when it began. The communications records came next. Over 11 months, I had preserved and organized every text message, email, and shared calendar entry between my wife and me related to the children, not just the cooperative ones, all of them. There was a period, about 8 months before the filing, during which she had been traveling heavily for work. I introduced into evidence a calendar export showing 63 consecutive days during which I was the sole parent present in the home. I showed the school sign-in and sign-out records for the same period, which matched. I showed the aftercare billing records, the soccer registration confirmations, the dentist appointment reminders that I had responded to, rescheduled, and confirmed. Then I introduced a set of text messages from the same period in which my wife had sent me photographs of her hotel rooms and restaurants and said things like, "Miss the kids, hug them for me." I said, "Your Honor, I'm not presenting these messages to criticize my wife for traveling for work. I'm presenting them to establish the baseline reality of who was physically present and responsible for our children's daily care during this period." The judge nodded. I said, "The opposing claim in this case is that primary custody should shift to a parent who, by the documentary record, was physically absent from the home for 63 consecutive days less than a year ago." I'd asked the court to weigh that claim against the record. One of my wife's attorneys leaned over and wrote something on a notepad and slid it toward the lead attorney. He read it. His jaw tightened slightly. The hardest moment came late in the afternoon. My wife took the stand. Her attorney led hers through a carefully constructed narrative. She spoke about her love for her children. She spoke about wanting to provide them with security and stability. She spoke about her income, her family network, her plans for a larger home in a better school district. She was composed. She was articulate. She was, in that moment, exactly what her attorneys had prepared her to be. Then she said something that wasn't in the script. Her attorney asked her to describe her vision for the children's daily life in her primary care. She talked about schedules and extracurriculars and the importance of seeing her succeed professionally as a model for them. And then she said, "I want them to understand that real stability comes from a parent who has built something." I wrote one word in the margin of my notes. Built. When I had the opportunity to cross-examine, I stood up and I asked her one question. When our son had his febrile seizure at 22 months, which hospital did we go to? She said, we went to Memorial, I believe. I said, it was St. Catherine's. The medical records are in Exhibit 3. He has a known allergy to a component in one of Memorial's standard fever protocols. That allergy is documented in his chart. I knew that because I was at the appointment when it was identified. Is that information you're aware of? She didn't answer immediately. I said, I'll move on, Your Honor. I sat down. The judge was writing. At 4:15, my wife's lead attorney requested a recess. The judge granted 15 minutes. During the recess, I stayed at my table. I drank water. I looked over my notes for the closing. The bailiff walked past and, very quietly, without stopping, said, "Good job in there." I nodded and looked back at my notes. When the session resumed, my wife's lead attorney said he wished to make a supplemental submission to the record. The judge said, "Proceed." The attorney said that in light of the evidentiary record presented, his client wished to revise her position on custody arrangements. The judge looked up. The attorney said they were now prepared to consider a joint physical custody arrangement. The judge said, flatly, "That's a significant revision from the original filing." The attorney said yes. The judge looked at me. He said, "Counsel for the respondent?" "I'm sorry, the self-represented respondent." "Do you have a response to this?" I stood up. I said, "Your Honor, joint physical custody is not what I'm asking for. I'm asking for primary physical custody with my wife receiving generous and consistent visitation. My children's lives are built around their current routines, their current school, their current relationships. The record I've presented today shows that those routines were built by me, maintained by me, and are dependent on continuity of my care. I'd ask the court to rule accordingly." The judge looked at both tables for a long moment. He said, "We'll take submissions for written closing arguments. I'll issue a ruling within 30 days. The ruling came on a Thursday, 26 days later. I was at the kitchen table when the email notification arrived. My daughter was at school. My son was napping. I had been trying to read a book for 40 minutes without retaining a single sentence. I opened the document. The judge awarded primary physical custody to me. He noted in his written opinion that the evidentiary record presented by the self-represented respondent demonstrated a level of sustained, documented, and consistent parental involvement that the court considers the clearest available predictor of future parenting capacity. He noted the discrepancy in the evaluator's testimony. He noted the communications record and the absence documentation. He noted the medical history incident specifically, writing that a parent's knowledge of their child's medical needs in an emergency is not a trivial indicator. He awarded my wife generous visitation, alternating weekends, 1 evening per week, and an extended summer schedule. He ordered both parties to participate in co-parenting mediation. I read the ruling 3 times. Then I put my head down on the table and I stayed like that for a while. My daughter asked me that evening if everything was okay. I told her yes. I told her she was staying in her school, in her room, in her house, with her Tuesday soccer practice, in her piano lessons, in her book club at the library, all of it. I told her her mom was going to see her every other weekend and they were going to have good time together. I told her nothing was going to change the things that mattered. She said, "I knew it." I said, "Yeah?" She said, "I told you the judge would know." I smiled and said she was right, and I asked what she wanted for dinner, and she said, "Tacos, obviously," and I said, "Obviously," and we went to the kitchen together. There are things I want to say to anyone reading this who is where I was 11 months ago, sitting in a parking lot with one folder and the feeling that the machinery of the system had already been set in motion against you before you walked through the door. The feeling is not wrong. Institutional knowledge is real. Resources are real. The gap between walking in with 3 attorneys and walking in alone is a real gap. But documentation is a language that courtrooms understand. It is not about overwhelming a judge with paper. It is about showing, through a record built over time, what your daily reality actually looked like. Not what you claim it was, what it was. I did not win because I was clever. I did not win because I outmaneuvered anyone. I won because for 5 years I showed up every day and kept a record of showing up. I won because when a paid evaluator contradicted herself, the paper trail was already in my folder. I won because the judge could see in the documents in front of him the actual shape of my children's lives. My wife is a good mother. She loves our children. What she did in that courtroom and the narrative her attorneys built around me came from a place of fear and from people who told her it was the way to win. I don't carry anger about it anymore. We are building something now, slowly, that I think our children will be okay with. We text about school events and coordinate pickups, and last month she thanked me for handling our son's ear infection while they were in her care, and I said, of course, that's what it looks like now. What I want you to know is this. The courtroom is not the end of the story. It is a single door. And doors can be opened by people who prepared. I was not the person in that room with the most money, or the most legal firepower, or the most institutional advantage. I was the person with the most records. Bring your records.